No nation meant for liberty can live forever in emergency. Yet before Congress stands a record unlike any in memory. 23 national emergencies declared by one president, 10 of them brand new, and even one named a crime emergency in the Capitol itself. Picture the resolute desk inside the Oval Office as those proclamations are signed, each one unlocking powers hidden within more than 100 different laws. The pens move quickly, the limits move quietly. And the question hangs, how did temporary become normal? Behind that number lies the National Emergencies Act of 1976, a statute written to end the abuses that followed the Vietnam and Watergate years. Congress sought then to place boundaries around the quick hand of the executive. But over time, laws meant to restrain have come to enable, for each new declaration opens doors that rarely close. Imagine lawmakers in the Senate chamber debating the Article 1 Act, a bill to force those doors shut after 30 days, unless Congress itself votes to keep them open. Even now the measure waits, hemmed in by habit and partisanship. But it was habit, not law, that built this problem, and habit cannot be undone by silence. Some defend the pattern as necessity. The world moves fast, they say. Congress moves slow. Yet the founders knew slowness can be virtue. They designed that friction on purpose, that men might cool before they decree. Why then do we treat every difficulty as a storm demanding one man's helm? The same Congress that formed our armies in 1775 and declared war in 1812 did not shrink from swift duty. It simply refused to surrender its own duty when the crisis passed. Picture the bronze doors of the Supreme Court on a clear morning in Washington. Inside, justices once heard a case called Youngstown Sheet Tube Co v. Sawyer. The year was 1952. President Truman, citing emergency, had seized the nation's steel mills to avert a strike during war. The court said no. Justice Jackson warned that emergency powers are a ready pretext for usurpation. His caution stands like a marker on the road we now travel. But one must ask, who still reads the signs? The National Emergencies Act tried to carry that warning forward. It required presidents to affirm each emergency yearly and allowed Congress to end one by vote. Yet the veto pen turned that check into parchment. Unless 2/3 protest, the declaration endures. Picture the roll call board lighting red and green in the House chamber. Eyes and nose flicker, but the result is the same. The emergency survives, the balance tilts a little more. What then is an emergency that never ends? For a time the meaning seemed plain: war, rebellion, plague. But the list has grown: tariffs on metal, sanctions over trade, even regulation of the internet. Walk the marble hallway of the federal courthouse on Pennsylvania Avenue, where lawyers carry binders marked IEEPA and NEA. Inside those volumes are the powers to freeze assets, redirect funds, and summon troops, all by proclamation. Such reach may appear strong, but strength without restraint is only appetite dressed in uniform. The founders divided authority not because they distrusted energy, but because they prized conscience. A republic survives not by swiftness alone, but by the slow consent of the governed. When one branch writes rules, enforces them, and funds them by its own hand, liberty drifts from law to will. Even so, no president stands alone in fault. Congress, through neglect, has ceded the field. Courts, through caution, have postponed decision. The public, lulled by convenience, has ceased to notice. Do emergencies justify such reach? Sometimes they must. Lincoln once stretched authority to save the Union itself, yet he hurried to Congress for sanction once peace allowed. He called it a case out of the ordinary law, not a model for routine. Even war did not make him crave ordinary rule by edict. Here lies the lost distinction between urgent remedy and permanent command. Picture 1976 again, President Ford at his desk signing the National Emergencies Act while reporters note the promise of reform. They believed they had caged the impulse. But when the court in 1983 struck down the legislative veto in INS versus Chadha, the bars came loose. From that year to this, few emergencies have ever died a legal death. Instead, they fade from news, but not from law, like embers beneath ash. How many such embers can lie beneath a constitution before the timber warms? That question shapes our age, for power once stretched becomes easier to stretch again. Consider the 2019 border wall case, funds redirected after Congress refused them. Federal judges in El Paso and San Francisco paused the plan, yet months later, new statutes offered the same authority by another path. Even defeat taught adaptation, not humility. You can see, on courtroom steps in El Paso, citizens holding placards with Article 1 printed in bold, as if reminding their own government who writes the purse strings. The pattern repeats because there is reward in overreach and little cost in restraint. Presidents claim success when swift, Congress bears blame when slow. But the Republic was built on something deeper than speed. It was built on the agreement that no hand rules unchecked. Picture the U.S. Capitol dome at dusk, its lights burning above a chamber half empty after another deferred vote. Power drifts toward whoever stays awake longest, and ambition seldom sleeps. That is how constitutions decay, not by one blow, but by thousands of small yawns. There is quiet danger in calling every trouble an emergency. For in a true emergency, citizens surrender much hoping only to survive. But when fear becomes policy, liberty becomes permission. Look to history, and you will see it repeat. Congress granted Woodrow Wilson vast powers in 1917 and found them still alive in 1921, when peace had long returned. Franklin Roosevelt used emergency statutes to shape trade and currency long after the banks reopened. Each act carried reason enough at its birth, yet time forgot to end them. The habit formed, and habit always asks for one more exception. Still, the story is not despair. In moments of correction, the people have stirred. Think of 1973, when Senator Frank Church held hearings that revealed how secret powers expand in the dark. Or of 1976, when lawmakers from both parties voted nearly as one to pass the reforming National Emergencies Act. Picture them on the Senate floor, hands raised together, believing they had restored the old boundaries. Their faith reminds us that restraint itself can be patriotic. The real question now is not whether presidents will reach for power, they will, but whether Congress, the courts, and the people will remember their equal share of guard duty. When senators in the 2020s proposed the Article 1 Act to limit emergencies to 30 days without express approval, they touched once more the lever of balance. Yet the bill stalled. Why? Because protest is harder than praise, and lawmakers rarely cheer each other for saying no. Still, there is hope in persistence. Each stalled measure keeps the debate alive. Each citizen who asks, what limits remain, keeps the design from fading. The Constitution endures because it rests not on parchment ink alone, but on the conscience of those who read it. Picture a civics class in Des Moines, where a teacher holds up the Constitution and asks why Article 1 comes before Article 2. The answer, once spoken, still has power, because reason must precede action. If ordinary Americans begin again to prize steadiness over swiftness, they will nudge their government back toward balance. The strength of a nation is not shown by how quickly it moves, but by how faithfully it observes its own rules. Even in war, the founders submitted to law. Even in peace, they feared its neglect. Theirs was a courage that did not depend on command posts, but on patience, the kind of courage that waits for consent before swinging the sword. So the path forward is plain though narrow. Presidents must treat emergency power as a loan, not an inheritance. Congress must reclaim its ledger and count what it gives. Courts must speak with clarity when the line is crossed, and citizens must watch, even when no headline blinks. Picture the marble corridor outside the Senate, once the cameras go dark, a janitor sweeping torn amendments from the floor. That quiet labor is what democracy sounds like when it remembers itself. Now the sun rises on yet another year of ongoing emergencies, trade, security, sanctions, crime, each still alive, though few now recall their origin. But somewhere between timidity and haste lies the faithful middle road. Law before impulse, deliberation before decree. If the Republic is to remain free, it must rediscover that rhythm. The Republic can be saved. And so I would ask you, citizen, when the next proclamation of emergency appears on your screen, Will you bow to its rush, or will you pause long enough to ask whether the danger is still real?